Good morning, everyone, and thank you for joining today for the Dallas Association of Young Lawyers Coffee with the Probate Court. Our speakers this morning are the Honorable Brenda Hull Thompson, the presiding judge of the Probate Court of Dallas County, Gregory W. Sampson, senior counsel with Gray, Reed, and McGraw, and Stephen Benton, financial counselor with the Elder Financial Safety Center at the Senior Source. Before we get started today, the course number will be 174095544 and is approved for 1.5 hours of CLE credit, including 0.25 hours of ethics credit. Again, that number is 174095544. You will need to self-report to the State Bar of Texas in order to get any CLE credit. Should you have any questions during today's program, feel free to use the Q&A function located in the bottom center of your screen. As a request from Judge Thompson, please do not submit any case-specific questions. I will now turn the presentation over to Judge Thompson.
Good morning. Good morning. I'm delighted to be here, and I'm delighted to have you with us. I'm glad to see everyone investing in themselves and investing in giving better service to the community, as well as better interactions with our fellow colleagues. It's been my pleasure to introduce and to host this Coffee with the Court 5 or 6 times. I've actually lost track, but it's always a delightful experience, and I hope that you will find some of the same camaraderie today with your colleagues that you find when we do an in-person presentation. So with that brief introduction, and I will launch it to the first topic, which is the efforts to develop a legal specialization. And let me just digress briefly. I want to thank all of the participants on this Coffee with the Court: Mr. Sampson, Mr. Snyder, Mr. Benton, and of course the Dallas Bar Association, Sherry Harris, Ms. Sherry Harris. I thank you sincerely for cooperating and participating in this event, and I'm sure that I speak for everyone who's part of this occasion today. I don't know how many of you all have heard about the efforts to develop a legal specialization in the area of estate, guardianship, and trust litigation. I have prepared a summary update on the legal specialization effort. And I'm going to be reading through it because I don't want to leave out any points with respect to where we are and what's happening. I can tell you that this is a very exciting proposition. I am on a committee that includes statutory, excuse me, probate court judges and lawyers from different jurisdictions. It's a pretty small committee, about 10 people. And we have been working on this for, I think, almost a year, and off and on. And we are trying to get input from various people about what would justify having this legal specialization. And so the new specialization area is estate, trust, and guardianship litigation. Obviously, this new specialization area has to be approved by the Texas Board of Legal Specialization. And you know that the only other specialization that's available for those of us in the probate, trust, and guardianship area is the estate planning specialization. And and we know that estate planning persons normally rarely engage in any litigation activities. We perceive a need to distinguish qualified, experienced professionals with special expertise in guardianship, trust, and estate work. And we also would like to not see guardianship, estate, and trust litigation work subsumed into the general category of civil litigation. Now, most of you know that there have been some big trials in Probate Court number 1. And there have been some controversial trials in our courts, our Dallas County probate courts. And these cases involve lawyers who primarily do civil litigation. and they believe that their civil trial litigation skills translate easily into what we do. Well, a lot of them probably have just recently become acquainted with the Texas Estates Code. And so we feel that it would be a greater service to the public to have qualified professionals identified who have had substantial experience with estate, trust, and guardianship litigation. Generally, the attorneys who come over to our court, and I've said this, who come over to our court to do probate litigation or trust litigation come from banking, they come from complex business litigation experience, personal injury, real estate law. They come from a lot of different places because there's this misperception or perception that all we have to do is provide trial skills as an overlay without actually understanding how our cases are built. And I will say that the contested matters in civil courts, in civil cases, tend to focus on discovery disputes and those kind or dispositive motions. And as you know, under the estates codes, the estates code, there are a lot of areas where there are contests. For example, motions in limine and questions about accountings and all those kinds of things. Those are contested hearings that may go on for several days and are certainly litigation type activities. Most contested, and you know that most contested estate and guardianship and trust matters are settled without trial, but that doesn't mean that they're settled without litigation activities. So we believe that that there is a need for specialization in this area. Obviously, there's going to be certain certification requirements that are always common to legal specialization. These certification requirements are going to be specific and some are general. And without bogging this presentation down, I will tell you that we have looked at the certification requirements in areas related to probate, for example, family law. We've looked extensively at the family law certification. Recently, there's a new certification in child welfare law. And we're looking at the process or the requirements, not necessarily the content. Now, as you know, probate overlaps in a number of areas. And so one of the knowledge base for a person who practices probate is requires a pretty broad-based experience. For example, probate cases can touch on family law issues, they can touch on real estate issues, they can touch on business issues. I mean, so you have to have a good working knowledge of information in those content areas, or you need to have good counsel to assist you. Let me talk about the general requirements, and I'm not going to go into depth because, as I said, this is a work in progress, but the general requirements include obviously bar membership, good standing with the bar, payment of the required fees, a certain number of years of practice, actual engagement in the practice of law. You'll need to have references. It's a peer review process. They'll look at the continuing legal education. They'll have experience requirements, and obviously there will be an exam. The specific requirements include trust, estate, and litigation experience. And so that means that you will experience and knowledge. And since, you know, law is a knowledge-based discipline, you're going to have to know cases and codes, the discovery rule, defenses, all those kinds of things. And so the subject matter area is going to be pretty extensive. It bleeds into a lot of things, creditor rights, and things like that. So At this time, where we are in terms of committee work is we have submitted a draft certification proposal to the director of the Texas Board of Legal Specialization for review. And he has asked for time to take a look at it. Now, this is a work in progress. That means that we are still massaging the whole area. And currently there's a survey that we are sending out to assess what kinds of litigation, what kinds of activities, what kinds of trial work should qualify as litigation experience, since we are not going to be saying you need to have, a dozen trials in 3 years. I mean, that's virtually impossible for anybody who practices in the probate, guardianship, and trust area. But what we're trying to hone in on are those litigation, the litigation activities that you engage in that are of a trial character, I guess is the best way that I can describe it. So recently I received received the survey that has been sent out to quite a few Houston lawyers, and the committee member who has sent me a list of lawyers in Dallas that she has also shared the survey with. And the survey is not exclusive to it's just a survey to try to see what people think should be included in terms of the activities that should qualify as trial experience. And so I have the list of people who have actually received this 5-minute survey. And Mr. Sampson has graciously agreed to assist me in submitting some additional names to receive the survey. Now, if you don't receive the survey, or you don't participate, doesn't mean anything. It just means you lost an opportunity to have some input in the planning process. But if you do want to be included in the survey and you do want to participate, I'll suggest to you that you either contact Mr. Sampson or contact Amanda in my office, and we'll put the names together to submit to her. Now, this is, as I said, it's a 5-minute survey, and it's inquiring about the types of activities, the types of things that we do in probate, trust, and guardianship litigation that should be assessed as being legitimate trial activities. If you have any additional questions about this effort, I'd be happy to entertain those questions. I've basically read you the list of all that I know at this point. So I would just say that you need to stay tuned if you think that you might be interested in eventually getting certification in the trial, guardianship, and trust litigation area. Thank you very much. At this point, I believe I will turn it over to Mr. Sampson. Thank you.
Thank you, Judge. Let me try to share a screen here so I can run through this PowerPoint. Do hope that that's up for everybody. Okay. What I'm going to share now is really just kind of an overview of the role of assessing least restrictive alternatives and supports and services when applying for a guardianship. Most of y'all know this, so I'm going to go rather quickly, but just kind of brush over the procedures. I'm going to then introduce Steve Benton here, because today's focus is really going to be on the financial management and helping to prevent elder abuse in this area of least restrictive alternatives and supports and services in particular, although we are going to present a lot of resources that will make it easier, hopefully, for you all to navigate the choices that you do have for least restrictive alternatives and supports and services. We'll dig down a little bit more after Steve's presentation on those topics, but I will get started with this general concept. You know, in 2016, the legislature enacted, or in 15 they enacted new rules effective in 16 that requires a finding that least restrictive alternatives have been assessed and they are not feasible, or to the extent they're feasible, then the limitations on the powers of the guardian will be imposed in the court's order. And certainly the same with supports and services. Those are to be considered with respect to any powers that a guardian would have. The goal of that is manyfold, but primarily it is to avoid guardianships when they can be avoided. And certainly with the aging population we have in the Metroplex and throughout the country, frankly, it's a good idea to avoid guardianships that could be avoided, where somebody can retain some independence. And on that point, the other primary role of these new rules was to allow us to limit, to the extent we can, the powers of a guardian so that the wards can retain as much independence as possible. Sometimes that's a moving target and things have to be adjusted over time, but the idea being, of course, that we want everybody to be as independent as they possibly can be and minimize the role of the court to the extent it should be minimized. So that's the purpose of the rules. And of course, that requires that in the outset of a case that we take a good look at our ward, as we do when we meet and visit about the situation, and we assess, and this would also certainly apply to the ad litem attorneys, assess exactly what the nature of their disability or incapacity is, and then try to tailor the different available least restrictive alternatives and supports and services to that situation. And we'll drill down again on that a little bit later with Judge. In the spirit of the coffee of the court, Judge has been kind to say that she will share some of her insights on some of these points as we discuss them later. And of course, we're going to try to reserve about 15 minutes at the end for questions. And so you have an opportunity to get some additional insights from the judge on some of these points. So let's begin with the steps in the process. Of course, you begin with the application, and you don't get very far without a CME. So we need to get that immediately at the outset of a case, because it identifies specifically, and we'll go into this in more detail later if we have time, the physician will identify the abilities and limitations of the proposed ward. And it will certainly address applicable abilities and restrictions that the physician thinks could apply. And that begins sort of to become your roadmap, which is ultimately what your application is going to be for the court, a roadmap about the condition of the ward and what kinds of powers should be given or withheld. The court investigator's office has a guardianship questionnaire that would be good to look at and assess your client with. You would also want to identify why a guardian's power should be limited or unlimited, and you have to be able to show whether alternatives were considered and why they were or were not utilized, and the supports and services that were considered and whether or not they were utilized and or do not apply. In the hearing itself, of course, you do need to make a record of your findings, and you certainly want the court to go along with what you're proposing. But it's important to note that there are two different kinds of standards of proof. And so for certainly the determination of incapacity, we know is a clear and convincing standard, as well as the appointment of the guardian and whether or not least restrictive alternatives or supports and services are not feasible. But it's really only a preponderance of the evidence that's required for determining whether or not a total or partial incapacity is the proper approach. And the specific findings that we'll drill down on a little bit later with respect to incapacity with or without supports and services for determining the residents, whether to vote, whether they can drive, and whether they can marry. And those were a preponderance of evidence standard. The role of the CME in this evidence, as I mentioned, is absolutely essential. And of course, you'll want to review the court investigator's report and see if you can present witnesses that can more specifically guide the court as to why certain alternatives or supports and services are or are not feasible. You don't need to go through every possible application of the supports and services or of the alternatives. I'm sure Judge would appreciate your being succinct on that. But by identifying exactly what is the nature of the incapacity, you can kind of cut through a lot of those that don't apply and focus on those that do. Then in the order, of course, you have to have several findings. There's a full versus partial incapacity determination at the outset. Then, of course, you have to determine the feasibility of less restrictive alternatives and the feasibility of supports and services. There is, again, that specificity of whether they lack the capacity to choose a residence, vote, drive, or marry. And I think Judge may comment, if we have some more time later, about the determination of whether or not they can possess firearms. And that's a federal law that kind of plays into to the process. Then, of course, you would want to identify limited authority that the guardian would have under the orders. And there's the required notice to peace officers, which I'm sure you're all familiar with by now. And then, of course, any other particular orders that might be necessary. In the statute, there is a definition of supports and services. It's at 1002.031. By the way, I'll mention now that there's an outline that you will all be getting together with this, slideshow, the PowerPoint. And in that outline, which Judge and I presented to the Advanced Guardianship Seminar in 2016, there's an appendix, which is part of Judge King's ad litem manual he was kind enough to let us use. If you haven't seen it, you really need to take a look at Judge King's ad litem manual. I believe the latest iteration of it is 2017. It's available. There's a link to it, I believe, on the Dallas County Probate Court's website. You can also easily find it on Probate Court number 1 of Tarrant County's website. That's where it originated with Judge King before he retired. It is an excellent outline. If you haven't read it, you really need to, specifically if you're going to serve as an ad litem attorney or frankly as a guardian ad litem in a case. It's got some excellent guidance, but for our purposes today, the most useful thing, and I think it's probably the best list I've ever seen, there's 56 points of either least restrictive alternatives or supports and services that he provides in his appendix. It's attached to the outline that you'll be able to get after this seminar. And what we tried to do, Judge and I, when we made this presentation before, and we'll try to do in the time we have today to some extent, is help you identify those supports and services or alternatives that are particularly applicable to and helpful in the situation that your ward is in, so that you can identify those supports and services that are really tailored to your situation. And we break it down based on those that would apply primarily to guardian of the person matters, those that would apply primarily to guardian of the estate matters, and then those that require action by the court, and those that you can do without any action by the court. And so again, we'll talk about those in the later segment of the talk today. But I did want to refer you to that and hope that that's a useful resource for you. And of course, the other thing that we're trying to accomplish today is to provide some of the key, and there's many, many that we cannot provide in the time we have or in the space we have on these materials, many, many resources, many services that are available to assist you in determining what kind of supports and services or alternatives might be available to avoid a guardianship or to limit the guardianship in your ward's case. But specifically in the statute, we've got these items that need to be addressed, and that's food, clothing, or shelter, physical or mental health, personal decisions, and we talked about those, and we'll dig down on those a little bit later with respect to capacity for making those decisions. And then, of course, there's the management of financial affairs. And here is where we are really blessed to have the guardianship services of Senior Source, which I know a lot of you are familiar with. And if you're not familiar with, you need to visit their website. But you're going to get an opportunity to hear from Steve Benton here in just a moment, who is going to outline some of the great things that they could do, particularly in the financial affairs management field. But they do so many other things for wards and proposed wards. And they also are a key part of Judge's Financial Safety Center, which he's also going to visit with you about shortly. So I am going to turn this over now to Steve and let him take care of that. And as soon as I can unshare here. I'm not able to do it for some reason. Sherry, can you help me unshare so Steve can jump in?
Yeah, I've tried, Greg. You need to unshare. Should be a little bar that you find up there.
Yeah, and it's I see. It's in my top monitor. Excuse me. There you go.
Okay, good morning. For those of you that are not familiar with the Senior Source, it's a nonprofit social services agency serving the needs of seniors in the Metroplex area for nearly 60 years. In fact, we have the same birthday as the Dallas Cowboys. I don't know which organization is more important at this point, but our mission is to ensure the financial and emotional well-being of older adults. If you want to shorten that, making older better. And so with the experience, we certainly know the senior demographic well. Senior Source receives funding from various sources, including a multitude of individual donations, foundation grants, such as the Boone Pickens Foundation, Meadows, Community, United Way, and others, as well as some fundraising events, such as our annual Spirit of the Generations Luncheon at the Anatole every year, and functions like Jub Jam. If you're familiar with George Dunham of The Ticket, he puts on Jub Jam every year with his music buddies at Billy Bob's, big supporter since we helped him with decisions for his parents a while back. As you can see from the title slide, the seniors desire to stay aging in place, preserving that independence. And so the money management bill paying program is an effective tool in this least restrictive alternative toolbox. So this money management bill paying may eventually morph into a rep payee relationship and then eventually a community referral for guardianship. But it's a starting point to keep them aging in place and keeping them out of guardianship. Senior Source, a little bit more, as Greg shared, we're guardian of the person for currently 92 seniors in the Metroplex. 83 were appointed by our Dallas County courts here. We're also the ombudsman for all of the nursing homes and assisted living facilities in Dallas County. So our long-term care group makes visits twice a week to all of these to advocate for residents. Extensive volunteer program, Senior Services Corp. You'll see a lot of our senior volunteers tutoring in the elementary schools and so forth. They're the grannies at the hospital, rocking babies and so forth. And we also put on free will clinics thanks to DAYL. Several of you have probably volunteered at our facility in the past for these free will clinics, and we thank you for that. So what we're going to talk about briefly is the Elder Financial Safety Center. Then we'll move over to this financial capability and capacity, because it is a gateway issue to senior safety and security. Money drives where you can live, how you can live, and so forth. We'll look at this relationship between the client and the Senior Source, what we provide, then the next steps that are needed when necessary, this progression as things deteriorate, and then finally our contact information. And so let's talk about the Elder Financial Safety Center. It's a unique formal collaboration of three entities, and you'll see up there on the screen the Senior Source, the Dallas County Probate Court, and the Dallas County District Attorney's Office. It was launched in 2014. Judge Thompson was instrumental in its formation and continues to be a key supporter and frequent speaker in publicizing this unique effort in dealing with senior needs and elder financial abuse. And so you see we all have our lanes in, but this collaboration has been very successful, as prior to this we were kind of siloed in dealing with elder financial abuse and weren't quite as effective now that we've worked together. APS we worked with very closely. We wish that they had joined us as a collaborating partner, but it wasn't able to happen, but we work very closely with them also. My primary role is scams and frauds and financial exploitation, and we'll talk about that shortly, but you'll see the different responsibilities. Of course, the Dallas County District Attorney's Office is in the prosecution business. Because of this funding and the start of the Elder Financial Safety Center, they were able to hire 2 full-time prosecutors one full-time investigator that do nothing but senior cases now that were kind of get buried in the pile in the past. And so we have people specifically to go to with referrals there. Of course, the Dallas County Probate Court, which you're more familiar with, the protection aspect, the investigation, placement of guardians and wards. Annual monitoring is a big deal because that removal of unfit guardians, I think, and the judge might correct me later, I think we removed 6 unfit guardians last year. And then, of course, the senior source, prevention, of course, prevention, protection, prosecution had to have that alliteration in there. And so we do a number of situations at the senior source. One, career services. People reach their late 50s, early 60s. Maybe they've been laid off, or they're realizing that their income is not enough to survive in retirement, and they're looking for jobs. And it's a very delicate situation to get seniors involved in work. So we do a lot of counseling along those lines. Financial coaching, basic needs, benefits, this money management bill payer program, exploitation relief, and then finally financial literacy. We do a lot of educating. We put on seminars, scams, frauds, financial exploitation, financial planning. Money Smart for Older Adults is a 4-week course that usually the classes are 30 to 35 in size and have been very successful in helping them with financial planning, budgeting, and getting their financial house in order. Because again, financial money and finances is the gateway issue of their safety and security. And so that's very important. All right. Here's what we've done in the past 6 years, served over 30,000 people. We've protected over $130 million. That's kind of a funny way to say it, but those are outcomes. These could be recoveries of monies we've recovered, savings, benefits that we've acquired for seniors, and so forth. Anything to make older better. And we've educated over 52,000 people during this time period, and you guys will be added to that number at the completion of this process. Here's the slide I wanted to spend most of the time on, because that's what we're kind of about today, this cognitive decline and how it's affecting finances. We talked about the safety and security of seniors, this money being the gateway issue. It decides where you can live, how you can live, what your life is like. And as we age, there's that increasing vulnerability. 70% of the assets, you may not realize this, 70% of the financial assets in this country are owned by 50-plus-year-olds. And these 50-plus-year-olds, their ability to discern decreases over time, and we'll talk about that shortly. Technology is leaving them behind, and they have a target on their back. As we talked about, they have the money, and their ability to discern is deteriorating. The old question of why rob banks, because that's where the money is, and they are really an easier target, the seniors are. So scams, frauds, financial exploitation presentations, we do it at church, senior centers. I had a conversation, I was in a conversation with Judge Thompson the other day, and she was talking about these key trigger emotional words that drive us. And she was alluding to the fact you can be walking in the mall and see the big red sale signs, and we're immediately drawn to things. And seniors are really no different, except they have different trigger words that get them going. What's driving seniors is basically fear. That's the big one, these feelings of fear, greed, and romance, which we'll talk briefly about here. But these are emotions that they're dealing with. The number one senior fear, surprisingly enough, is not death, but it's running out of money. And so this fear is sowed by these con artists that will call and say your Social Security number has been compromised. And this leads to a trail of trying to save their income. The IRS is calling. You've got an IRS problem. And it's hard to communicate to all the seniors out there that the Social Security Administration and the IRS never call. And it's just a fact that they've got to realize that all of these are scams. The grandparent scam continues to be working. That's where a grandson calls grandma supposedly, and he's in jail, needs bail by 3 o'clock, needs $1,000. and she frantically goes to the bank and tries to get it wired to get their grandson taken care of. And so they're easily fooled. Their cognitive abilities to discern that that's not really their grandson. And a lot of these scams are asked to be solved with the sending of an iTunes card. And they just can't connect the dots that how could the IRS be settling up on iTunes cards? But it is a real concern. In fact, this grandparent scam, I thought we had pretty much had that tied down because banks have the ability now with the Texas Elder Financial Protection Act to lock down accounts. And we can talk about that briefly, but they never had that ability before. Now they can when they suspect scam and frauds are taking place. Your brokerage firms and your other financial institutions can freeze an account for a period of time until hopefully sanity comes in the form of relatives or whatever. So anyway, also the fear of this running out of money, that's why when they're contacted that they've won the lottery, even without ever entering, that doesn't connect with them. They fall into that trap. So they fail to connect those dots. So let's talk a little bit about this frontal lobe problem because that's where the decline has taken place. The frontal lobe is where you make your logical decisions, where you make your finance decisions. And it doesn't really fully mature until your early 20s, 22 to 24, somewhere around in there. And that's why your teenagers make such stupid decisions because their logic, their frontal lobe isn't quite developed. And then you have this nice bell curve of making making decisions throughout your life. And as you age, it begins to deteriorate. And again, those dots don't quite connect. So it may not be Alzheimer's, dementia, it just may be simply old age. And I saw this in my mother-in-law who lived with us last year of her life, that she would get so focused on something and you could not use logic to get her off of those thoughts. So it is real. So that's where capacity comes into play. You know, the judge teaches, and you'll probably hear this in a minute, when somebody lacks capacity, there's never a period after the word capacity. It's lacks capacity to do what? Lacks capacity to drive, lacks capacity to manage money, to live independently, and so forth. And so there is a danger in isolation of these seniors. We've seen the dysfunction of the family. A lot of seniors now made the choice years ago not to have children, and they're now alone in their senior years. They're isolated. Maybe there's dysfunction in the family. It breaks my heart when a lady will sit across from me and I'm probing for who's the family, who's around. And she says, I haven't talked to my daughter in 25 years. And you're just stunned, but it's the reality that's out there. And so there is that's going on. Now, I did mention, fear and greed, but romance, you probably thought that was silly for me to bring that up as an emotion or a feeling, but it is big, it is real. Some of our biggest losses we're seeing out there are in romance scams. I'll talk about two principal demographics here. The 60 to 75-year-old female who's maybe divorced, single, or widowed and looking for love one last time. They're incredibly vulnerable, and they usually get involved in these romance schemes that are coming from overseas. A military guy that's over there trying to find his way back and needs some money. It always ends up in sending money. You'll have these ladies that are so emotionally involved with these people, though they've never seen their face. Sometimes they've never even talked to them on the phone. It's all been a text relationship or a Facebook relationship with fake pictures and everything else. They'll sit across from you and say, yes, I know it's a scam and I'll quit doing it. And they'll leave your office and go right to the store and buy another iTunes card to send over there. So we're seeing big money, $100,000, $150,000, $200,000 lost, their entire life savings. Some people sell their houses because, my love of my life, George, who I've never met, is going to come into town. We're going to buy a house together. So one in 10 at age 65 experience cognitive difficulties, 1 in 3 at age 85. So it is prevalent. That's probably been the most stunning thing to me of how prevalent it is. And so let's don't leave the males out of it. The male demographic that is the problem right now is the 80 plus, maybe mid 80s. They've been married their entire adult life and they probably were the primary caregiver of their wife as they went down. They've never been alone from the time that they were growing up with their parents to being married, and now suddenly they're alone. They're widowed. They're living in a 3,500 square foot house, and they are lonely. They're being stalked at Sam's and Walmart and Costco, and literally being approached by people because they know how vulnerable these older gentlemen are. We've had a problem. Let's see, I'm not supposed to say gypsy. The Roma population in this country, every major city has this group, and you'll find them stalking elderly gentlemen in the parking lots and at these stores, and they'll end up moving into their homes. So we've had several cases of that where we've had to rescue the man, and it's tough to get through logically that they're being scammed. They just don't understand. So I wrote an article a couple of years ago in a senior magazine. If you thought taking dad's car keys away was tough, wait till you try to take away his computer. So that's a big problem today. These portals into the home that seniors have opened through the telephone and through the computer, that's where all of this stuff is starting. You're opening doors and welcoming in scoundrels that you would never give the time of day to. But here you are letting them into your life. And that's where a lot of the problems are. I can't tell you how many times I've heard people say, but he was so nice. Well, of course, all con men are nice because you wouldn't talk to him otherwise. But again, I hear the families threaten their seniors with, I'm going to have you committed. They don't understand how things work in guardianship. And so we work closely with seniors. Are they being taken advantage of by their own family? Unfortunately, 61% of our cases are family oriented, where mom's in memory care and daughter's got the power of attorney out spending all of her money. We work with APS, as I mentioned, quite closely, and to see APS really focuses on the physical safety and security of an individual mostly. They'll come in, are they safe? Do they have food? Do they need certain things? But when it comes to money, we get a lot of referrals to them because their plate is so full. And so they're taking care of mostly the physical stuff and leaving the financial stuff to us. So I'll move on here quickly. It's getting to be a problem. You know, probably the biggest one, I'll just give you one example. This guy hit the trifecta. Nicest guy in the world, lives over by White Rock Lake, been into his home several times. He was one of the demographics I talked about. He had lost his wife after taking care of him and had $1.5 million in the bank and in investment accounts. And he was being not only romance scams, he had won the lottery and he was waiting for his winnings, and he had won a Mercedes convertible. And so they were after his money, and he was sending it to his lady that he was going to get married to in Florida, which he had never met, and trying to convince him he was being scammed. You couldn't penetrate it. So even when we got the courts involved, they put on a temporary restriction. We got his account frozen at Chase, locked up, so he couldn't get his $1.5 million, put him on a budget, the only money he could touch. Well, the scammers worked around that and were able to get him to go to the bank with his good credit and take down a $12,000 signature loan, and that money was gone within 24 hours. So I had to take some more restrictive steps in that case. But I know I spent a lot of time sharing this, but these are big problems. It's only going to get worse. The baby boomers are reaching retirement age. What is the stat? 10,000 per year reaching 65, and they're woefully prepared for retirement. And money is all about that. So let's get into our program quickly. And basically, I've got a video here. Hopefully, we'll see if it comes up. This is Shannon Simmons, who's our Shannon Miller now. She got married, and she's head of our bill payer unit. I'm not seeing the little thing, so we might not be able to hear her. And doesn't look like it's coming up, but she does an incredible job. She's actually in a seminar today. You might have heard from her today rather than me if she was available, but she kind of outlines what they're doing during the COVID. There we go. Let's see if we can get this going now. Sherry's probably helping me out here. This will only last a minute or two.
Hi, my name is Shannon Miller, and I'm the Senior Financial Case Manager of our Money Management Services area. We assist low-income seniors in making sure that their monthly bills are paid on time. Oftentimes, seniors function well in many different aspects of their lives, but sometimes need assistance in the area of finances because of what we call diminished financial capacity. This is sometimes due to cognitive impairment, but sometimes physical impairment too, such as strokes or vision loss or a variety of other concerns. Some signs that someone may be needing assistance with their finances are continuous late bills, eviction notices, utility cutoff notices, or someone spending through their income quickly before all their basic needs can be met. Under normal circumstances, we have a team of highly skilled, trained volunteers who we are able to match with clients in the community to make sure that their monthly bill paying needs are met. However, due to the coronavirus health risk, we are not currently doing home visits at this time, but we are still accepting new referrals. We are doing initial assessments over the phone, which allows us to continue to get to know new clients and see how we can still assist them during this time. We have a variety of services at the Elder Financial Safety Center and the Senior Source, and we always assess to see if we can still assist them through other services or through other community referrals. So if you think that you or maybe a loved one or someone you know could use money management assistance, please still go ahead and reach out to us and let's see how we can work together towards a dignified solution.
Okay, that was Shannon, and here's how it works. We're almost through this presentation, and you'll see that there's this is a voluntary program. There's a referral and assessment process. You'll see that Adult Protective Services probably our #1 referral to us, wanting us to get involved as things that they've found with their visits. We get referrals from the community, from neighbors that notice people are in need of help, and then also social services and healthcare agencies, including facilities. Bring us in. This is a partnership. Both parties need to agree that the person that's wanting the help or needing the help agrees to bring on a volunteer, and they can discontinue at either time, either party. That partnership agreement involves us taking the checking account, being able to observe it. We're really providing 3 basic services: budgeting, bill paying, and bank reconciliation. And so we are visiting probably twice a month, puts eyes on the individual. You can probably get the business done in about 10 minutes, but you stay an hour or so, you're building a relationship, and you're just watching and seeing if they're having any additional problems. What this involves is writing out their checks for them. They are still in control. They are the signatory on the checks, but it allows the bills to get paid and so forth. So it is volunteer. They're vetted and trained volunteers, and twice monthly, and it allows them to stay independent and age in place. Now, again, either party may terminate, and it's got to be a good match, and that's the way it works. Qualifications, basically assets. They can't have over $100,000 in liquid assets. Doesn't count their house and other things, but $100,000 liquid assets. If they have more than that, we kind of figure they can go hire it done at our recommendation. Income, 38,000 as a single, 52,000 as a couple, again, for the same reason. We do make some exceptions. I myself volunteered for an individual for a number of years that he had $500,000 in Schwab, but he had been disabled neurologically since he was in high school from a car wreck, and had spastic movements, was not able to be understood, and he obviously needed help. We were introduced to him when his 94-year-old mother was wheeling him up to the ramp to the dentist and fell over dead at a heart attack, and Wilson was, I'm sorry about the name, he was alone for the rest of his life. And so we did an exception there, and it was quite a relationship over time. The individual has to be 60 plus and reside in Dallas or Collin County. And so, as I mentioned, that it might morph into a need for more service, and we are also rep payee for a number of individuals when they really are not, they are no longer able to sign their own checks. Basically, we become rep payee and we pay all their bills from the office there. And again, send volunteers in to maybe take some petty cash money that they can spend to their apartment or whatever. And then it may eventually evolve into a community referral to guardianship. So with that, hopefully I've stayed within my time constraints. We've talked about the Senior Source, Elder Financial Safety Center, and the Money Management Bill Payer Program. Your law practices, if you encounter scams and frauds and financial exploitation, you can use us as a resource. Feel free to give us a call. Just had a referral last week of niece felt her aunt was being exploited, and in fact the aunt had disappeared about a year ago and she had no idea where she was. The caregiver had actually run off and hid her somewhere, and we were able to track down the location and start the process of recovery, not only of her house and money, but of the individual aunt herself. So that's just another story. There's a million stories in the Naked City, and hopefully I haven't taken too long, but there's our contact information. And with that, I guess I can release the screen. And there you are, Greg.
Well, thank you, Steve. I think we could spend a whole hour and a half on services that are available through you guys. And you do a great job. There are many other resources that you'll see that we're going to try to get to here in a little while, but a good first stop could always be the Senior Source. So let me share this screen here and get back up. As Steve mentioned, the Elder Financial Safety Center is a great resource, particularly for helping to prevent elder abuse and particularly financial abuse, but abuse of all kinds. And he did a really good job of explaining it. This is a picture of their website. You can access it through the Probate Court's website, from Senior Source, and the DA's office as well. So I just wanted you to see that there's really a great resource there, and there's lots of good information available on that site. Judge, did you want to, since you initiated this, did you want to add anything about the Financial Safety Center?
Well, I can say that it can be very easily implemented in communities with or without resources. We were very fortunate when we attempted to implement this concept in our community. We got a substantial grant to implement the center. However, the key to the center's mission is the collaboration and the common mission. And so we have made presentations across the country, actually, and to national organizations and to other groups in this area. And so I encourage you to, if you can be part of a catalyst in a community, to do something to affect the safety and welfare of seniors, I encourage you to do that.
Thank you, Judge. And of course, we have an obligation, if we see it, to report it. And this is a great place to start for that. The other place you can certainly go here is APS. Here's their website. They certainly provide, through the Family and Protective Services, some oversight and can investigate claims. And anybody that's doing this, like those that are watching or have done it for very long, know that this is a huge problem. It's an epidemic, particularly the financial, but also other kinds of elder abuse is really not just on the rise, but getting very dangerous. So we are those who can probably do an awful lot to stem it when we see it. And so anyway, these are some resources that can certainly help there. As we talk about supports and services, and we're going to have to go kind of quickly through a lot of this, but I will encourage you to take a look at the resources that are available on the slides that you'll receive later and in the outline. But as we talk about tailoring, whether or not the supports and services can be available to help avoid or limit a guardianship, it's really critical. The judge pointed this out when we prepared this thing 4 years ago, that one of the essential starting places is identifying the kind of incapacity that you're dealing with. And there's three categories the judges identified, and I think it's relatively easy to break down the different resources and services that are available between these three different categories. And Judge, I'll let you comment on them.
Yeah, I just want to jump in and say that we get important information from not only your application, but from the CME that informs our capacity analysis. And once you have a clear vision of the capacity analysis for your particular client or the ward, then you have a filter through which to assess and evaluate the alternatives to guardianship, as well as any supportive supports and services. You see on the screen that there are three categories essentially of people who are served by the guardianship services. And so that is the filter that you look through. You look at the supports and services and the alternatives that are available in these categories. Other important filters are the resources available for these services. There's no point in identifying a service for which there are no resources or no availability for the particular individual. You also have to assess whether or not there's family or kinship support. Some of the resources, the supports and services and alternatives require kinship or family support. That's an important assessment to make. You also obviously have to look at the medical needs, both short-term and long-term, of the proposed ward who we're assessing whether or not to put under a full or a partial guardianship. So you have to approach the whole idea of supports and services with filters in mind. And I encourage you, if you serve in the role of a guardian ad litem or an attorney ad litem, to always stop and assess and evaluate the pros and cons of each option before you waste time going down a path that's not going to be productive. I'll throw it back to you.
Thank you, Judge. These three categories are certainly important to identify, and as I said, there are some resources that we'll hopefully get to later that will apply more directly to those that you can identify. As I mentioned in the outline, there's a breakdown of Judge King's excellent list of 56 alternatives or supports and services in this fashion. There's tools for avoiding guardianship or limiting guardianship of the person, and tools for avoiding guardian of the estate or limiting it. And they're broken down by with or without court action. So obviously without court action would be things like, doing a statutory power of attorney or supported decision-making document, those kinds of things. And with court action could be, emergency protective orders or, or other things. We'll talk about those. So we did break those down in the outline. We probably don't have time to go into them very in much detail, but we'll hit a few highlights here later to the extent we have time. And of course, then there's tools for minimizing or terminating guardianships that hopefully we'll be able to utilize alternatives and supports and services that are available. And geriatric care managers, I have found to be an extremely useful resource. I know the court likes to appoint them from time to time, and I don't know, Judge, if you want to comment about the use of geriatric care managers, but we are not experts in managing people and their aging brain or their intellectual disabilities, like somebody like Steve Benton and great folks at Senior Source. We're not psychologists. We're lawyers, but we can rely on people who have experiences and licenses in this area, and I think is a great resource. Judge, did you want to add anything on that?
Yes, I want to. I'd like to add that geriatric care providers can be wonderful in the role of assessing the situation for the court and for the families. Obviously, everybody in the family has an opinion with respect to what's best for the person, but there's nothing like professionals' insight into a situation. And a professional can can calm the waters so that a decision can be made, because a professional care assessment looks at some of the filters that I just covered with you and makes a recommendation to the court. And it's not binding on the court, but it certainly informs the court's decision, and it informs the families or kinship people with respect to what kinds of roles they can play on a continuing basis, so that they aren't burdened with the guilt of making a decision, or they are not short-sighted in terms of what kinds of supports and services or alternatives could be available to their person. The worst thing in the world is to put together a piecemeal plan that has a short-term life. Okay, you want to have something that's durable and that's functioning. Not to say that we don't modify plans, but what I'm saying is, if you can tailor your plan to meet the specific needs of a person up front, that's obviously preferable.
Thank you, Judge. And of course, looking at other tools for minimizing or terminating a guardianship, we always have to consider the possibility, at least with respect to guardian of the estate, the use of trust, management trusts, 142 trusts, pooled trusts like the ARC trusts, and freeze agreements, which can allow us at least to hopefully reduce the need for a bond. And so these are things that the courts will regularly work with. I was just recently involved in a case where I was an ad litem appointed, and it was a personal injury case. And we had to look at a lot of different alternatives, and ended up having a management trust created. But it was a unique situation, and we had to kind of look through all the alternatives before we could come up with the one that was really the best. And so, again, the outline discusses all of these things, and Judge King's outline discusses them even better. So I would have you consider those. And then, of course, there's the opportunity to pay small estates into the either to a family member or into the court registry. These are other things that you can do to minimize the need. So obviously, many of the alternatives are going to depend upon whether or not, or frankly, an assessment of whether or not the ward can make certain kinds of decisions is going to depend on their capacity. And there are a number of different capacity determinations that you might have to make depending on the situation. So we'll take a minute here to talk about capacity and the different levels of capacity or standards that are necessary. And I'll try to go through these quickly. Again, the outline covers them a lot more detail. But of course, one of the first determinations is whether or not you have a total or partial incapacity. And then the capacity to marry, drive, vote, choose a residence, and then your ability to participate in your active daily living chores. Determining a capacity for alternative planning is essential with respect to if you're going to do allow any testamentary capacity type planning. What contractual capacity is needed, powers of attorney, and trust creation capacity. So we'll go into those here now. So it is a rebuttable presumption of capacity at the outset. That's your starting point. And the code, of course, determines when, what the standard is for determination that you need a guardian. There are task-specific capacity determinations, which are in the CME. And if we have time, we'll look at the CME, but I think you're probably familiar with it. But there's a number of items that the physician needs to check off as to whether they yes can do or no cannot do these things. And that is an absolutely critical starting point for you to understand what kind of capacity issues are in play with your particular ward. Then there's the total versus partial incapacity that I mentioned. In a partial, of course, there's specific powers or duties of the guardian that need to be limited. And you need to determine the limitations based on whether you can or cannot assist with supports and services. Marital capacity, although it's not specifically defined here in Texas, the Family Code does provide that a marriage may be annulled if a party did not have the capacity to consent to the marriage or understand the nature of the marriage ceremony because of a mental disease or defect. And since the marriage ceremony, the party did not voluntarily cohabitate with the other party. So that's out of the family code. Determining whether or not somebody has a capacity to drive, we all know that this is always a challenge when this arises. It's kind of the last bastion of independence, and so it's often something that the ward fights hard to keep. According to Texas DPS eligibility requirements, in order to receive a license, the driver must complete the written application, pass a vision test, and demonstrate sufficient knowledge and recall of Texas laws to pass the written driving knowledge test and demonstrate sufficient physical coordination and judgment to pass the actual driving test. And as you probably know, after you get 12 years on a license renewal until you're age 79. After that, it's every 6 years. And after age 84, it's every 2 years. And sometimes I've found, frankly, that encouraging them to go take a driver's test will put an end to the argument that they should be able to drive. Voting capacity, this is an interesting one. There isn't really a specific discussion of voting capacity, except that the Texas Constitution and the Election Code refer to incompetent or totally or partially incapacitated persons without any definition of them. And then Texas Estates Code, of course, defines an incapacitated person in the standard for granting a guardianship. Interestingly, I had looked to see if there was any more guidance from the ABA, and in fact, in 2017, they passed a model rule that focuses on whether or not there's an expression of a desire to vote, and then whether or not they can actually vote and make a decision is kind of a later determination. And Judge, did you want to comment on that? We're in an election year, and this could be an important factor.
Well, I will say, generally speaking, that if a person expresses a desire to vote and they seem reasonably alert as to what they want to do in terms of, the content of their expression about the need to vote, I will generally allow most people to retain the right to vote. I mean, I don't believe that we should hold a person who has some incapacity to a higher standard than the rest of us. And so I'm very, very open to retaining the capacity to vote or the right to vote if it's requested, and certainly if there are expressions of support for that, I will do that.
Okay, thank you, Judge. Then, of course, capacity to choose your place of residence, the level of incapacity or evidence that's needed to rebut the presumption that you do have that right. That is the case in Texas. It isn't provided in the statutes, but it's probably a level of capacity similar to what it would take to enter a contract, since you probably do have to either sign deal with contractual matters such as rental agreement and or an assisted living contract. So that's a factor there. I'll try to quickly, because we're getting short on time, talk about the testamentary capacity. You all are probably familiar with that. Contractual capacity, you have to have at the time of the transaction an ability to appreciate the effect of what you are doing and understanding the nature and consequences of that act and the business that is being transacted. For powers of attorney, setting aside a power of attorney for lack of capacity requires a showing that the principal did not understand the nature or consequences of his act at the moment of execution, which is similar to the contractual capacity. And then trust creation capacity for lifetime transfers generally would be subject to a testamentary capacity standard, but for irrevocable trust, there's an additional requirement of donative capacity, requiring an ability to understand the effects of the disposition that the disposition may have on the future financial security of the donor and to those who may be dependent on the donor. That's from the restatement of trust. So if you're going to be using some of those alternatives that involve documents like that, you certainly want to make sure that your board has the capacity. And again, we're not psychologists or psychiatrists, but we can hire them. And there are several out there that will assess your client for you. And I would recommend that if you're in a situation that is not absolutely clear.
There's one point I'd like to make at this point, and well, we probably should highlight this for you. There are some cases where we have to make capacity decisions where they are a situation of a dual diagnosis. Sometimes you will have a case that there's a history of mental illness involved, and you need to pay particular attention to the fact that the capacity assessment, it can be interwoven into an assessment of their mental incapacity or mental inabilities at a particular time. So this is an area where we have to be really careful that we reach the correct conclusion. And we focus on basically supports and services for people who largely have, physical disabilities. However, I want you to keep in mind that looking at supports and services and alternatives to guardianship, it also includes those people who may possibly have a dual diagnosis. And so that means that you also have to go into looking at supports and services and alternatives in that area. And we don't include this in our presentation, but I just happen to think that there are a number of non-traditional organizations, as well as the ones that we've outlined in our presentation, that can provide supports and services in the mental health and mental illness area. So I want you to be mindful of the fact that sometimes these cases are not just a single focus analysis. You have to do a broader spectrum analysis.
Thank you, Judge. Up on the screen now is a decision tree for lawyers that actually comes out of the ABA Handbook for Lawyers, put out by the, I forget the name of the commission. I think it's the Elder Commission of the ABA. It's a fantastic resource. It's available online. And this is just a nice little opportunity for you to kind of, if you're dealing with, should I or should I not let my ward sign something, this is a nice little algorithm that can help you in determining whether or not you should. It breaks it down into, whether they're mild problems or severe problems. So anyway, I just leave that for your study later. Also, of course, other great resource is the Alzheimer's Association. One of the things they're famous for is knowing the 10 signs of dementia. Here's just a sample of that. A little questionnaire that you can fill out and with respect to your ward. And so that's available, of course, at the Alzheimer's Association website. If we have time, we may share some more from their website, because again, they are a great resource for anybody that might be dealing with dementia. As we talked about, least restrictive alternatives, in Appendix D of Judge King's ad litem manual, talks about some highly used ones, which of course would involve advanced directives, durable powers of attorney, and supported decision-making agreements, all of which would require capacity, as we just discussed. And then there's some other commonly used tools that we really don't have time to dig down into now, that the court, I think, has identified that they see regularly, and that's emergency protective orders. Of course, there's the annual review process and an opportunity to adjust the guardianship each year. Master pooled trust should not be ignored or forgotten as an easy way to put funds into a trust and not necessarily have to have the requirements of a management trust. Mediation and family settlement agreements are fantastic ways, obviously, to resolve problems, particularly if there's a lot of strife in the family involving a ward. And as Judge mentioned, the geriatric care managers are a great resource. We don't have time to go into this. I'm going to try to wrap up to give time for questions as we promised. But here, highlighted in the materials, are the provisions that you would want to review with respect to the physician's determination of some of these important levels of ability. And then, Judge, I'm going to let you comment real quick about, because this was a surprise when we talked about it, about the federal firearms prohibition statute and its effect on determination on guardianship.
I don't know how many of you have ever participated in a restoration proceeding, but you know that in the Texas Estates Code, there is a provision for restoration of rights. Under that section, there's a provision for restoration of all of the rights, including the right to own or possess a firearm or ammunition. However, if you look back in the guardianship section and you look under what findings the court should make with respect to award and put the findings in the actual order, you don't see a specific indication of the need to include a finding with respect to firearms and ammunition. Well, that appears to be a kind of lack of segue backwards to what's required in an order. However, people have asked, well, what is the authority for putting a restriction on firearms in a guardianship order? And what is the basis for the firearm restriction in the first place? Well, I refer you to the statute, the federal statute that's on the screen, 18 USC section 922, subsection G4. You will note that this caption of this section has a very offensive title. It says persons adjudicated as mental defective or committed to a mental institution. Now, if you drill down in this provision, there's a section in there that says if you have been determined to be mentally incapacitated. So that is the authority for the provision in your orders that says that we are placing a restriction on the possession and ownership of firearms. And that's the basis for the restoration, the inclusion in the restoration provision. So be aware of that provision. You'll see there, my screen is a little small, but I think it's like the second or third one down that has to do with determination that you have the inability to manage your own affairs. And so that's where the authority comes from. We are, of course, subject to federal law as well as state law. So just be aware of the fact that if you get a request to correct your order to include that, that's why we are authorized to include that in the order.
Thank you, Judge. And I'm going to close now so we can get to questions with just this notice that in Appendix 3 here on the Dallas County website for the probate courts, you'll see a resource list. It's a little outdated. So Judge was kind enough to give me an updated list that I've now put in the rest of Appendix 3 of resources that are available under different categories here, all of which you can either access by website or phone, and certainly addresses. So I would recommend those to you after this talk. And so, James, I think I'll turn it over to you to see if we have any questions.
Okay, well, thank you all for the presentation. And we have a couple of questions from our participants today. The first one is going to be for Judge Thompson concerning the certification for fiduciary litigation. When do you anticipate the certification will be launched? And do you believe there will be any overlap, if any, between that certification and the board certification for probate and estate planning?
I think that to answer the second question first, I think that a distinction is being made between the board certification for estate planning and the new proposed specialization, because we don't want to duplicate what's already in place. And of course, the argument would be, well, why would you want to create a specialization that is essentially the same thing? Now, the obvious segue question is, well, there is some overlap. And so obviously some of the people who have the estate planning certification may be in good position to qualify for the new proposed certification. However, as I said, it's a work in process, so I don't know what it will look like. Now, to answer the first question, excuse me, there is no, we don't have a specific time frame. We have submitted, as I indicated, a preliminary draft to the Texas, to the director of the Texas Board of Legal Specialization for preliminary review. We don't have a time frame. We are trying to get input from a number of attorneys. One of the first efforts was to see if the attorneys would actually support this. And so we had to assess whether or not there were other people who were like-minded who agreed that this would be something that they'd be interested in pursuing. And of course, we have to be careful that we shape the guidelines so that the intended audience, that is the intended, prospective persons to be certified, fit into the criteria. So we were looking at the pool of people who would likely be certified and trying to assess why we felt that they were distinguishable from anybody else. And I think that that's pretty, for the reasons I gave you earlier, I think that there's a distinct difference between just general civil litigation skills and having general civil litigation skills and probate experience. And so I'm one of the proponents. I think that it's, I mean, I think it's an exciting possibility. I think it's overdue recognition of the wonderful skills that many of you have. And but I'm rambling, but I want to tell you that there's no specific time frame. We're just working the process at this time.
Okay, thank you. And this second question was initially proposed to Steve, but I'd like to get some input from everyone else after Steve has had the chance to expand on his previous answer. But when you're approached by someone who is a friend of an elder who is potentially being abused or is potentially being scammed by, say, a member of their church, or as you previously mentioned, one of those persons that's following an elder person's home in a parking lot, do you have any recommendations for them when they have no family members who can protect them?
Well, the reply I made to that individual, I think it was Sarah, was that we are a resource. And so we would love for you to refer them to us. We do a lot of counseling and probing as to who is around this person, who are some possible support areas they have. So again, I would just encourage you that if you're suspecting some financial exploitation and scams or frauds, to get them in touch with us at the Elder Financial Safety Center, because like I said, we deal with this every day, and every situation is unique based on family, lack of family, and like I said earlier, a lot of times it is the family that's the problem, and you've got to kind of ferret that out. So all I can say is if you run into people that are having issues like this and being defrauded and scammed, the faster you get them to us, the better. A lot of our counseling is the horses are already out of the barn, and basically you're just trying to get their life pieced back together and see what's left, unfortunately.
Okay, and Greg or Judge Thompson, would either of y'all like to expand on that question? Have anything to add?
Well, I'd just like to say that I am passionate and enthusiastic about this topic because, I mean, the simple truth is if we don't try to protect people, we get to take care of them. So if your family members or your friends or people in your community lose their resources, guess what? They wind up in nursing homes. They wind up living desperate lives. Mr. Benton indicated that there are a number of elder orphans out there, people who have nobody. Their siblings can't help them. They have no children. They have no spouse. They are veterans who are displaced or disaffected. I mean, these are people who deserve help. And so I encourage you as members of the bar, and I think you're going to get some ethics out of this presentation, that it is your responsibility as an officer of the court, as a proud member of the bar, to be proactive and to ask questions, because frequently people are scammed and they're too embarrassed and too ashamed to say anything. And that includes your family members, your parents, yourself. I mean, how many times have you gotten something you didn't expect to get, or you didn't get what you expected to pay for? That's a scam. That's a fraud. They perpetrate it on you and on seniors and everyone in between. So, you know, it's little things, or I don't consider it a little thing, but it's, you know, practicing measures to reduce identity theft, to practicing taking time to look at your grocery bill to make sure you're not billed 7 times for the same thing. I mean, there's commercial fraud in it, and it may not be intentional, but seniors and other people are very vulnerable to being taken advantage of and to losing their resources. These sweetheart deals are so sweet. I mean, they should be on sale on Valentine's Day. So it's a major problem out there, and I implore you. That's why I basically been a one-person speaking bureau. It's important. It's really important.
And really not much to add there. In the interest of time, I will just say that it's really unusual for somebody to have no community. So it behooves us to take a little bit of time to try to find out, maybe there are remote family members out there who do care about this person, that just need to know the situation, or a church or other community. Veterans, you know, there's some great support there. And a lot of the resources that are provided in the materials are places you can go if these people have connection to those communities. I would just encourage you to do that.
Okay, and Greg, I've got one quick question for you, or at least hopefully it's quick. Do you have any recommendations for young or newly licensed attorneys who are handling the first contested guardianship, and specifically recommendations for keeping the best interests of the proposed ward in the forefront while properly representing your client?
I'm sorry, the audio got a little rough there. The last part again about...
Sorry about, I'll ask the whole thing again. Do you have any recommendations for newly licensed attorneys who are handling their first contested guardianship, specifically with trying to keep the best interests of the proposed ward in the forefront?
Well, certainly that is our duty. And I would say if you're a young attorney, there are great experienced attorneys, and certainly the judges will want to, you know, to help you be a better lawyer. But obviously you're not going to be able to ask the judge in your case to help you with your particular case. But there is a mentorship program through the probate section. I would reach out to some experienced lawyers. We all would like for younger lawyers to love this practice area that we love, and to learn from us. And we can connect you with people that might have a situation that we know about that's very similar to yours, and get you some advice. But absolutely, it is all about the best interest of the client. And to the extent you feel uncomfortable with a matter, get some help. And I think there's a lot of experienced lawyers that would be willing to step up and help you. Hey, call me, and I'll certainly connect you if I can't help.
Well, with that, I believe we are out of time. So thank you to all attendees who were watching today, and especially thank you to Judge Thompson, Mr. Sampson, and Mr. Benton for their time today. If you'd like to receive a copy of the materials that were used in today's presentation, please reach out to Sherry Harris with DAYL. And this program was recorded and will be available online soon. Do not forget to self-report your CLE credit from the State Bar. Once again, that course number is 174095544. Thanks, and y'all have a great day.
Thank you all.